Hello, this is Kevin Thompson. I'd like to welcome you to the Davis McGrath LLC IP webinar series for May 2nd, 2012. Today we'll be covering the trademark clearance process. The recording and slides will be posted at our blog, the address shown on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for our mailing list. For those of you who need Illinois MCLE credit, please send your name and ARDC number to me if you haven't already done so. Our next webinar is coming up on June 6, 2012, again for about half an hour from 12 to 12:30 on copyright infringement and damages. Today we're going to go for about 30 minutes and cover some trademark basics, talk about the different types of marks, what makes a distinctive mark, what makes something descriptive or generic, whether or not you have a duty to search, and scope of searches that people will go through when they're trying to clear a mark for use in commerce. The search process itself, talk a little bit about international searching, and then for a good chunk of the time I'm going to go through some examples from recent decisions of the Trademark Trial and Appeal Board in cases dealing with likelihood of confusion, and go through those and some which came out one way and some which came out the other, and I'll talk about those a little bit. As always, if you have questions throughout the webinar, please feel free to use the software to ask your question. We'll also have a period at the end for questions as well. Simple trademark basics here. Trademarks are symbols used in commerce to identify the source of particular goods or services. And trademark rights come from use in commerce. So you can have what are called common law rights, which are your rights in the particular areas in which you're doing business. So you'd have those rights regardless of whether or not you achieved your registration. There are state levels of registration, so each state has their own trademark laws, and there are also, we'll talk about this a lot more, is the federal system, which is if you want a registration that covers all 50 states. And federal law protects marks that are used in interstate commerce, which is different from intrastate or services that are performed only within one state. These days, there isn't very much that doesn't impact interstate commerce. In fact, just as an aside, that the reason that we have these systems, this intellectual property protection for federal protection, it comes through the Commerce Clause. And so that's why there's a requirement that marks be used in commerce. It also provides protection for those who want to ramp up and start using a mark in commerce through a system called an intent to use application. You do have to prove that the mark is in use and in order to qualify for registration, but you can file an intent to use application and your rights begin as of the date you filed that application. Puts people on constructive notice of your rights. Now, there are different types of marks, and when we're clearing marks for use by clients, it's helpful to first look at the mark itself and try to determine what type of a mark it is. The strongest type of mark is something that's fanciful or coined or an arbitrary term. The next level is suggestive marks. Those are ones in which it takes some sort of a process or a thought to realize just what it is that the mark is referring to. It's not immediately obvious. The next level down is descriptive marks, in which it is obvious. You know, there's the wording in the mark itself. It makes it fairly clear what the services and so forth would be. And then generic terms are the common terms for particular items. Generic terms can never be registered, and we'll provide some examples of those as well. Some fanciful or coined terms, think of Kodak, Pepsi, or Xerox. Those are all terms that don't mean anything in and apart about from themselves, and words that were invented or coined. Arbitrary ones are words that exist normally in the English language, but not necessarily for the particular goods or services. For example, Camel for cigarettes and Apple for computers are considered arbitrary marks because Apple by itself does not normally mean computers. But it is a common term that's used in a new way, and so therefore it's arbitrary as to how it's used in this particular mark. Suggestive marks, think of ones, some examples here are ones that were found to be suggestive. Greyhound bus. Greyhound implies fastness and speed, and the it's suggestive of the transportation services that the owner of the mark intended. Another older one, Orange Crush. It implies an orange flavored something, but exactly what a crush is, it isn't immediately obvious from it. It's in this case it would be an orange drink, but it's not immediately obvious from the term exactly what a crush is in terms of the mark. Descriptive ones is ones we see a lot of. It seems to be in common parlance among naming agencies to send clients back with marks that are merely descriptive, in the sense that it's pretty obvious from the mark itself just what it is that it means. And here's an example of an oldie but a goodie. These people tried to register bed and breakfast registry, oddly enough, for a bed and breakfast registry, and it was found to be merely descriptive. And merely descriptive marks by themselves are not registrable on the principal register, which is where most marks go. In the U.S., there's another system called the supplemental register, which is where marks that are potentially capable of acquiring distinctness over time can be registered. And they're entitled to use the circle R to show registration and so forth, but it's also provides protection for others filing similar marks, but it doesn't presumptively mean that what that is operates as a trademark. If somebody should have a supplemental registration and want to sue someone, for example, they would need to still prove to the judge that what they're using functions as a trademark, whereas something on the principal register, that's presumed, and it's a rebuttable presumption. So marks that are merely descriptive can be registered on the principal register if they have some means of showing acquired distinctiveness, such as use for a long period of time or recognition in the marketplace and so forth. There's lots of factors that go into that. Now, merely generic is the lowest level, and what you have is marks that are showing on your screen here are marks that were one time considered trademarks, but became the common term for the particular thing that they're talking about. Aspirin was a mark of the Bayer company. Cellophane, escalator, laundromat, touchtone, and zipper were all trademarks of particular companies, and over time these became to be the common or generic name for the particular services. It's always helpful when you're helping someone come up with a mark is think of what the generic term for what you're describing is. So, like for example, if the Otis elevator company had introduced the escalator as the escalator brand People Mover and decided that People Mover would have been the generic term, and used it that way, and were able to convince people to use it in that fashion, it certainly could have helped them in the long run as to maintain trademark protection for their escalator term. Now, when you're clearing a mark, and somebody comes to you and you try to determine whether or not that something is available, the question often comes up is whether or not there's a duty. Do I really have to do this? And there's a case out of the 11th Circuit in 1999 called Frailing Enterprises versus International Select Group, Inc., in which these people's failure to search was found to be intentional blindness. And so there's been other decisions in other courts. Some courts have considered the failure to search at all to be evidence of carelessness, or it would not help to find that there was any lack of willfulness on their part. So it's certainly advisable to do some type of searching. The question then comes is, well, what do I have to do? And that there's, from a straightforward perspective, what type of searches you do. There are searches you can do of the Federal Registry. The Trademark Office has an online database that's searchable of not just registrations but applications, and you can figure out the status of them, and it's very user-friendly to download documents, and you can review documents in the case file. It's wonderful. It used to be you have to mail away for these things, have a company go out and make photocopies of them, and it's wonderful that information is available online now. Then there's state registries. Each state that has trademark protection has their own registry for trademarks. And then there's common law type searches in which you try to find through business directories, the internet, and so forth, evidence of people using trademarks in commerce. Now, the actual process involved is sort of a two-step process. The first level is the lowest level, what we call a knockout search, and that is where you do a quick search of the federal and common law available databases to try to figure out whether or not there's something directly out there or close for a particular mark. And the online database the Trademark Office has is wonderful for that purpose. There's plenty of search engines that you can use for searching the internet. You can use Google, you can use Dogpile. It really depends on what it is that you're particularly trying to find. These days there's lots of competing search engines out there, and you'll find different results in Bing, for example, versus Google, and it's certainly advisable to do a knockout search at the very least. The next step, which is above and beyond that, is hiring an outside search company to obtain what's called a full or a comprehensive search. And they're usually about an inch or two thick in size, usually several hundred pages. And they're kind of expensive, and they take a couple days if you want to get them back. I mean, you can certainly get them back much faster if you want to pay a lot more, but you can spend $600, $700 on this search if you want to get it back in a couple days. And they search, again, the federal, the common law, the state databases, and internet domain names to see what's out there for a particular mark. And then usually what you do is you review it and you write an opinion as to whether or not a mark is available or not, based on the level of risk that you foresee as what's out there. And these types of opinions are normally relied on in litigation over a mark to show whether or not somebody adopted a mark in good faith. Like if you're able to show that you applied for it after having searched fully, and for example, you didn't find evidence of the other party out there, it certainly could be shown as a good faith effort to clear the mark. And so again, it's not absolutely required to go through that level, but a lot of companies prefer to have such a full search on file for marks that they are potentially going to be taking nationwide or get large exposure for. So that they know that going into it, there's less likely that they would need to change the mark. Could happen down the road if somebody objects. You've got to come up with a new mark for your product, and that's a sort of a bad thing to have to do after you've put forth a lot of money and effort into trying to launch something. So it's certainly advisable to consider, what's reasonable under the circumstances for a particular mark or a company, as to, how much searching that they need to do. And that's a decision we always leave up to clients for, as to, whether we can certainly recommend, but, so the ultimate decision is up to clients. Now, the next question that comes up is, what about international clearance? What can you do if you're going to try to use a mark in more than one country? The standard answer is that you can order searches through foreign counsel. You can do sort of a quick type of a knockout search through those countries that do have online databases similar to the United States. You can order a search through an outside vendor similar to the full search here, and you can obtain that information. But the real question is whether or not you trust yourself as a lawyer, for example, who's licensed only in the United States, to interpret the results and laws of another country. And so that is why it's usually, if you're going to do the full type search, to order those type searches through foreign counsel who can review the results and say, based on their country's laws, whether or not a certain mark is clear or not. Now, when we're evaluating risk in terms of proceeding with the mark, we often look at likelihood of confusion, which is one of the reasons a mark can be refused. And there are 13 factors that have come out, and the Trademark Office adopts. They're called the DuPont factors, named after a famous case, In re EI DuPont de Nemours and Company, which is from 1973. And there's 13 of them, and they look at all different factors of how the mark is used. But the most common is the similarity of the appearance, sound, connotation, and commercial impression of a mark. And it's also important to keep in mind what are the goods and services and the trade channels in which these goods are sold, and then the conditions under which sales are made. For example, an impulse buy, where somebody might spend a couple bucks and just buy it at the local convenience store, versus a sophisticated purchaser who carefully reviews and meets with people before signing a multi-million-dollar contract. Those are certainly very different conditions under which sales can potentially be made. And so it's always very interesting to look at certain marks as to how they're used and sold. And so we're going to get into these cases these are all cases that were decided in the last, I'd say 5 months from the Trademark Trial and Appeal Board, which is the first level appellate body at the Trademark Office. If you file an application and it's refused, and you go through the process with the examiner, who issues what's called a final refusal at some point, saying, you've either got to overcome, this objection, or you've got to file an appeal to the Trademark Trial and Appeal Board. These are decisions of that board. They are reviewed, and you sort of file a brief explaining why you believe the mark is entitled to registration. The examiner is then able to file their own brief in which they believe why the mark is not entitled to registration, and then there's an examination of the paper record by the board. There are certain extreme cases in which that might have oral arguments, but most of the time it's decided on a paper record. And so these are sort of helpful cases to look at, because they're ones that, for example, if you're trying to overcome a refusal, you would cite these cases in support of a position you would take, and also they are decisions. They're very helpful to show real world examples of the types of issues that can come up when you're trying to clear a mark. So these are all marks that did receive final refusals and then were taken up to the Trademark Trial and Appeal Board. So the first one we're going to look at is from the case In Re the Leeds Group Inc., which is the name of the applicant here, and their mark Cosmetic World was filed in Class 16 for a newsletter about the cosmetic and beauty industries, but directed solely to those who work or operate in those industries. And the examiner cited a registration in a separate class, Class 35, which is for retail store services in the field of perfumery, cosmetic products, beauty products, and hair products. In this case, the examiner argued that the marks were identical, the goods or services were closely related, and there was no limitation on like the nature, type, or trade or classes of purchases that could be made in the cited registration. And then, the applicant argued that while, these people might operate in the same broad cosmetic and beauty industry, these actual goods or services are not related, and it's a completely different class of trade in which these particular marks would come out. And so the board looked at the DuPont factors, and admittedly the marks indeed are identical, but the important factor for them was that the newsletters for the applicant here, this Cosmetic World newsletter, was intended for members of the people who work in the industry, and so they're not directed at normal consumers. And so while a retail store may have a newsletter, they certainly would have a newsletter that was targeted more at consumers, such as sales or other promotions for the store. And so, this particular factor, weighed in favor of the applicant. And so they found that, focusing on those who work in the industry is a completely different channel of trade than, the more retail or consumer focus of the registered mark. And those who work in the industry who certainly would be classified as sophisticated consumers. So in this particular case, even though the marks are identical and that they are somewhat related services, the board overturned their refusal and allowed the mark to proceed to registration. Our next one is a case called In Re Rogers Petroleum Inc., and the mark on the left is the applicant's mark, which is for Pure Java, the original energy drink and design, which is for coffee prepared and sold on site at applicant's retail convenience stores in Class 30. And then you have another one on the right, which is the mark cited by the examiner, which is again Pure Java, but spelled a little differently and with a different design in coffee in Class 30. And in this case, the board found that the goods were indeed legally identical. It didn't matter that the coffee in the applicant's mark was prepared and sold on site at applicant's retail convenience stores, because the registered mark wasn't so limited, and so that really didn't matter. Coffee is presumed to be in the same channel of trade as another type of coffee. In the case of then the board turned to the marks themselves, and you look at the mark on the left, and it's pronounced Pure Java, and so is the mark on the right. And so even though coffee and Java, and probably also the word pure, would be common in the coffee industry, And so there's evidence in the mark in the record to show that that this mark is indeed weak. There are a lot of other registrations with similar marks, but even weak marks, marks that aren't particularly strong or distinctive, are entitled to protection from very similar or identical marks. And so in this case, this particular refusal was affirmed. Our next case comes from In Re Nissan North America, Inc., in which you've got a mark owned by Nissan for their customer relationship management services in the field of vehicle maintenance and repair. And in this case, their trade channel is limited to applicants' authorized vehicle dealerships only. And then the mark on the right is for a mark for online business services, for tracking, managing, and catalyzing inquiries that come in through a website and providing online responses to those customers, and then conducting and analyzing the needs and results of customer surveys. In this one, if you look at there's actually 4 marks here. There's 2 on the left. There's a word mark, one-to-one service, as well as the design mark that includes those sort of swoops on the top and the bottom. And then the word mark on the right is one-to-one-service.com, which is quite similar. In this case, Nissan conceded that the marks were indeed similar but not identical. So focusing on the services themselves, there's the examiner was arguing that that the services are of a type that could emanate from a single source, in that that they certainly could have a customer response survey type company providing these online business services. They could be related to this customer relationship management services that Nissan's trying to register. And so the board looked at the services and said that that they certainly could be related. But in this case, Nissan had real strong evidence in the form of affidavits from its dealers, in which they said that these dealers had never, in all the years that they've been in business, had never encountered or come across in their particular industry a service similar to the one on the right, which is the registered mark. And so this evidence of completely different channels of trade was found to be relatively persuasive by the board. And again, these are real sophisticated consumers. These are auto dealers on the left for the applicants, and so they believed there was insufficient evidence of likelihood of confusion, even though the marks were so similar due to the differences in these services, and so this particular refusal was reversed. Oops. The next one is In Re Whole Soul by DAZ LLC. That's the name of the applicant. In this case, the mark on the left is for whole sole for hats, caps, headwear, jackets, sweatshirts, t-shirts, pants, and shorts sold on premises at applicant seminars and events and through applicant's website. And then the mark on the right is for similar services in goods, actually, in one in the same class, apparel, namely robes, in class 25. As well as in class 24, wearable full-body towels and all-purpose towels. And so in this case, the mark is identical. It's whole sole in both cases. The goods are indeed somewhat related. They're both in the same class. They're both generally types of clothing, although a robe is not something you normally wear out in public, versus hats, caps, headwear, jackets, and sweatshirts. But the examiner put forth evidence that that there's plenty of registrations out there for robes as well as this casual outerwear type clothes, and so the goods are related, it should be noted, and the applicant made a big deal out of this, that they limited their application to only sales at their seminars and events and through their website. But the board pointed out that the registration on the right is not limited in that fashion. And so in theory, they could also be selling similar goods at their own seminars and through their own website. And so, potentially there could be confusion out there. And, the test is not actual confusion. The test is likelihood of confusion. And in this case, the refusal was affirmed. The next one is In-Ray Dayton Power and Light Company for Green Connect versus Green Connected. Green Connect is the mark on the left, which is from a power company, a public utility company, in which the customers could purchase renewable energy certificates. And so that's what they're using Green Connect for. Green Connected on the right, sort of a long, complicated recitation there, but essentially it's a website that points people to companies that are green companies or eco-friendly companies. And so Green Connected through their website allows people to find these businesses. And so first looking at the marks themselves, the board found some crucial differences between the design marks themselves. The dominant portion of the registered mark is the GC logo, where the dominant portion of the mark on the left is their electrical plug design, as well as the real prominent use of the word green and connect. Whereas Green Connected on the right is much smaller than the GC, and they've got admittedly leaves in both marks, but the leaves look a little different. So the board thought that the commercial impression of the marks were indeed somewhat different. So that factor weighed a little bit in favor of the applicant. In this case, there's lots and lots of marks out there that have green and connect in them, and so the marks are relatively weak and descriptive, and so the public would generally look for other elements in the mark and try to distinguish these services. And then while these services do have a similar focus in that they're all focusing on eco-friendly type services, what you actually have is quite different actual services rendered to those areas. You've got the public utility company offering their renewable energy credits versus just this website with general information connecting consumers to green businesses. And so the board found it very important that despite the similarities in the marks, these two companies are not competitors, and as so reversed the refusal. And we've just got a couple more of these to go through. We have In-Ray Cookware for Life LLC, which is the applicant on the left, and that their marks are for life. The word mark as well as a design mark incorporating the circle and a water drop logo, and they're for pans, kitchen utensils, namely salad spinners, mixing bowls, and serving spoons. And then the mark on the right is for life in a sort of a rectangular design for housewares and cups, dishes, and containers for food in class 21, which is the same class as the mark on the left. And then they've got their own registration for the mark Cookware for Life. Although that's the name of the applicant, that's not the mark that they applied for. They applied for life. The board itself looks primarily at the mark for life on the upper right, but did make a note that they had this other registration as well. So these goods are related. There were plenty of registrations that the board had been pointed to by the examiner that showed registrations where these pans and kitchen utensils are also sold by companies that also sell the cups, dishes, and containers for food on the right. Same general channels of trade here. And since the marks were identical in sound and similar in appearance, the refusals were again affirmed. This one's an interesting one. It's In-Ray Steamboat Springs Chamber Resort Association, Inc. They applied to register Biketown, USA. Notice there's a space between Bike and Town here, between Bike and Town, for organizing athletic competitions, namely bicycle races in Class 41. Whereas the registration on the right is for promoting the interests of consumers through printed material and so forth, but the board focused on the last part where they would arrange for sponsors to affiliate their goods or services with promotional contests. And that's what the examiner hung his or her hat on, is the fact that the mark on the right is for these promotional contests, which might be bicycle races, which would be similar to the mark on the left. And so, the services were for, relatively similar, but not necessarily related. It didn't seem very likely. There's some potential for overlap here. That these, a company who is looking for promotional things relating to this bicycle race might come across, the company on the right for, they're arranging for sponsors, and that was theoretical and speculative in minds of the board. And so you look at the marks themselves. There's a space in the mark on the left, but they found that not to be particularly significant. They didn't think that people would see that and find the people would remember that there was a space. And the marks are relatively essentially identical, but the board focused on the differences in the services, and you found that to be sufficient to overturn and reverse the refusal. And here's our last one. This is called In-Ray Republic Bike, Inc., which is for bicycles, excluding tires, whereas the mark on the right is, again, the identical mark Republic, but this is owned by Goodyear for tires. And so, the applicant believed, even though they're in the same class, that their bicycles excluding tires, that they're certainly not selling tires, they're selling bikes, wouldn't be related to tires. And here, the marks are identical. And, when the marks are identical, there doesn't have to be as close of an association between the goods or services as it would otherwise have to be, especially if they're in the same general class or the same general channel of trade. The board is constrained to look at the registration as it's written. Can't read a whole lot more into it than what it is. And even though it's Goodyear, that doesn't currently normally produce bicycle tires, they did find evidence that they had in the past, and certainly could again under the name Republic. And bicycles are certainly very related to tires. They rely on tires for their function. It's really hard to use a bike if your tires aren't in good shape, and so they're certainly related in that fashion. It's certainly possible that somebody with a Republic bike could come across somebody with a Republic tire and think there's potentially come from the same source. The bike company tried to point to the fact that they'd used their mark for a good period of time and never run into any problems with Goodyear. That's really not important at this level. The test is not likelihood. It is likely to confusion, but not actual confusion. So just because there weren't any real actual evidence of confusion out there, doesn't mean that the potential couldn't be this confusion out there. So I've gone through those cases. This would be a good point if anybody has questions, if they want to raise them. Again, you just use the software to put your question in, and it'll show up. I do see a question here from one person who was wondering again if there would be a recording made of this particular webinar, and yes, it'll be available on our website. I'll show the address again in a few minutes. And then there's another question that came up, and I'm trying to get it to display here. Yeah, the first question is it beneficial to register a mark in Illinois if federal registration is obtainable? And the real difference between the two is terms of scope and effect. In Illinois, registration protects you only in the state of Illinois, and they're very inexpensive to get. They're not really registered according to the same standards as a federal registration is, and so they're certainly not that hard to obtain, and they're certainly probative of the fact that that you have something that you believe to be a trademark, and you're certainly using it in commerce in some fashion. And it's certainly beneficial. Like, for example, if you try to get federal registration and you're unable to do so, you can certainly try to register in the states in which you're doing business. But you sort of get what you pay for with the state registrations. Your mark is then in public databases that can be found through searches, but it doesn't provide as much benefit as a federal registration would. And then the next question is, do you think in the cases of the whole, sole, or republic questions, whether or not the mark, the outcome would have been different if the applicant had applied in a design format? In the case of some of the other marks that were earlier, they were words and or logos, perhaps subject to separate applications. But in this case, they both were word marks, and so the question is, what may have changed in both those cases if they were done as designs. And I think the problem with both of those, I'm going to go back a little bit to show you the whole sole screen again. The whole sole on the left, if you change that to a design, the problem is that the whole sole mark on the right is not. The whole sole mark on the right is considered a word mark, which encompasses all potential designs incorporating those words. And so, the fact that you're up against a word mark on the right, means that, potentially the mark on the right could look just like the one on the left. And so the board has to take that into consideration, and it doesn't provide as much benefit as you might otherwise have. And I believe that's the same case also with the Republic. Yes, that indeed was a word mark on that as well. And so the same thing would apply there. So it really wouldn't help. It would help more if you were trying to distinguish your mark from another design mark. But in this particular case, that's not what you're trying to do. Are there any other questions? Well, if you do have questions, please feel free to call or email me. I'd be happy to answer them. Again, our next webinar is coming up on June 6, 2012, again on copyright infringement and damages. Today's recording is going to be posted on the blog, which is blog.davismcgrath.com/webinars. It should be up by sometime tomorrow, hopefully, and should also eventually end up on YouTube and available for as a podcast through the as a video podcast through the iTunes store. It's a free podcast, And for those of you who need Illinois MCLE credit, if you haven't already provided me with your name and ARDC number, please do so. And the same goes for those who are watching the recording. If you would like credit in Illinois, please contact me with your name and ARDC number and how you viewed the webinar, and we'll go about getting you credit for half an hour. And I'd like to thank everybody for attending, and I wish everybody a pleasant day.